All right. Well, thank you everybody for joining us today. We appreciate you getting on this early webinar, and we appreciate Andrea and Angela coming to us and presenting this information. I know there are a lot of questions out there regarding tip pooling. I do ask that you keep your lines muted and use the chat feature for asking questions. We will be monitoring it during the webinar, but if your question isn't addressed, we'll make sure that it is at the end of the webinar. We are recording this, and we'll be sending out a recording to you at the end later on today so that you will be able to review this for future reference. And with that, I'd like to introduce Andrea Kirshenbaum and Angela Sanders. They are both with Post and Schell. I appreciate you guys coming on and presenting this information. I know it's ever changing, but I think being able to keep the conversation going with it is important. So with that, I'm going to turn this over to Andrea.
Thank you so much, Hope. I really appreciate it. And thank you for everyone who has joined us today. As Hope said, my name is Andrea Kirshenbaum, and I'm the chair of the Employment and Labor Practice Group at Post and Schell. And I'm here with my colleague, Angela Sanders. And the issue with tip pooling has been such a challenge. And I know that you all crave really clear lines as to exactly what to do. And with the change in administration, we now have a new set of regulations. And so we're going to walk you through what has recently happened. But in order to do that, we're just going to take a step back and just set the table so everyone's on the same page. And we are going to take questions. We're going to do our best to look at the questions as we see them. And if not, we're going to leave some time at the end for questions because we know that there are a lot of questions. And with that, I'm going to turn it over to my colleague, Angela Sanders. Thank you again. We really appreciate you joining us today.
So good morning, everyone. As Andrea said, my name is Angela Sanders, and I'm an employment attorney here in Lancaster, Pennsylvania. We're going to start. I know that most of you have some idea about how tips work because you're in this industry. But as Andrea said, it's never a bad idea for us to kind of all start on the same page. So we're just going to do a quick refresher of where the tip rules came from, why we care about them, and what the basics are for how they operate. So like most wage and hour issues, the tip credit and the concept of paying a tipped wage comes from the Federal Fair Labor Standards Act, which, as most of you I'm sure know, is a federal law that tells employers various things about how they can and must pay employees. Section 3M of the Act is where this magical language came from that essentially established a practice where employers of tipped employees were permitted to pay a cash wage that is less than the standard federal minimum wage. So in this day and age, I think everyone's familiar with the fact that $7.25 is our minimum wage. But if you are an employer of tipped employees, so employees who customarily and regularly earn more than $30 a month in tips, you have the option of paying a lower wage. Under federal law, it's $2.13 an hour, and then taking a credit, quote unquote, basically the tips that your employee receives as sort of making up the difference between the cash wage required for tipped employees and the $7.25 that other employees earn. So under our federal law, the tip credit is typically going to be $5.12 because we have a cash wage of $2.13. But of course, we can't just leave it there because every state likes to get in on the action and not just let the federal government tell you what to do, but also have the state tell you what to do. So in Pennsylvania, we have an equivalent law similar to the Fair Labor Standards Act called the Pennsylvania Minimum Wage Act, which quite frankly is very similar. It says a lot of the same things. But one of the key differences for you all in the Pennsylvania Minimum Wage Act is that there's actually a higher state requirement for the wage that must be paid to tipped employees. So our state law tells us that you have to pay a cash wage of $2.83 an hour. We're still following the overall rule that employees have to receive a minimum of $7.25. So your tip credit, or the amount that you're allowed to take credit for as an employer of the tips received by your employees, is going to be $4.42 an hour. And you will see as we go through this presentation, I'm going to repeatedly use $2.83 simply because that's what you all have to be following anyway. So as we go through some examples, that's why we're using that number. So how does this work? Now, I know that most of you did not come to this webinar this morning wanting a lot of intense math, so I'm not going to spend a ton of time on these math slides, but I at least wanted to give you a little bit of an example of how these work in action. And frankly, most of you are using POS systems, you're using payroll systems, you're very rarely doing this by hand anymore. So I'm hoping that at the end of a shift, your servers and bartenders and housekeepers are basically just going in and typing in what their tips were that they recovered that day, and the computer's doing this all for you. But just so you have a fundamental understanding of how it works, we have an employee who worked 30 hours. You're paying $283 as required by Pennsylvania law. So this employee has earned in cash wages from you, the employer, $84.90. Now, what does that mean? Well, we have to take our tip credit. So because you're paying $283, our tip credit is allowed to be $4.42, which is the difference between the $725 that all employees have to earn and the $283, which you've already paid. And at the end of the day, you can take a total tip credit of $132.60 because you're just going to take that tip credit, multiply it by the 30 hours, and that's the total tip credit that you are allowed to take. So what's this person's total wages? $217.50. At the end of the day, on your payroll records, it should appear that this person has earned $217.50. Now, they may have earned more than that because it could be that their tips that they actually collected that day were $150, and you're only taking a credit for $132.60. And that kind of takes us into some of our other, go ahead, you can go ahead back to the next slide. That takes us into some of our other issues for how this works. So one of our fundamental rules is that you as an employer cannot take credit for more tips than the employee has actually received. At the end of the day, the goal of the tip credit is to get tipped employees to the equivalent of if they had worked at $7.25 an hour. So they have to get to that number. If their number is smaller than that, you're going to have to make up the difference. So if we look at the example in the blue box, you can see that this is a scenario where same hours, the person has worked 30 hours, they've earned $283 an hour. We have to compare what they actually take home at the end of the day, both in the wages you paid to them at $283 an hour and the tips they collected, and measure that against whether they have earned the equivalent of $7.25 an hour. So at 30 hours, somebody making $7.25 would have taken home $217.50, same number as our previous example. We know from our previous example that the tip credit in this case would be $132.60. 30 hours times our tip credit gets us $132.60. So at the end of the day, we can take this person's earnings, which is $84.90. You can see there in the middle of the blue box. I just pointed at it as though you could see my finger. $84.90 is what this person would have earned at $283, plus they took home $132.60. And at the end of the day, the tip credit was $132.60. And at the end of the day, their total tips, if you look at the top of the screen, was $200. So they've taken home well more than what is required under the tip credit. Their total earnings are $284.90, and they only had to take home $217.50. So we're in the clear with this person. They have made their earnings. You have ensured that they meet the requirements for minimum wage, and they have excess income, which they will have to report as income. By contrast, if we look at the blue box, we have the same hours. The difference is that this employee only took home $100 that day. Maybe they had a slow shift, who knows? But at the end of the day, when you add their $100 in tips and the $84.90 that they earned in wages from you, they're short. They're only at $184.90, and they needed to be at $217.50. And so guess whose problem that is? That's yours. Now, most of you, like I said, I know I was a server, and at the end of the day, I had to go into the POS system, and I had to put in what my tips were so that the computer could run all the math for the employer. Again, I don't think most of you are doing this by hand, but it's important that you have a process in place where you are checking these calculations. And if your servers are not earning enough tips to satisfy 725, that you have a process to make sure that is paid. And, that may be very well based on shifts or the type of establishment you are. I mean, I certainly, know that sometimes servers do better at dinner than they do at breakfast. But you need to have those controls in place, and your credit can never exceed the amount of tips taken. So you can't take a credit for $100 if your server only received 50. You need to actually pay in the other 50 to get them where they need to be to meet minimum wage. The other major rule that applies generally for the tip credit, and you can go ahead to the next slide. And this is a lot of math on this slide. Again, I just wanted to kind of give you an illustration of the rule, but I would expect most of this is being done by either your computer system or your payroll system. When we are dealing with overtime is calculated based on the full minimum wage of $7.25 an hour, and your tip credit doesn't change. So if your tip credit is $4.42 when people are working straight time, it's going to remain $4.42 when somebody is working overtime. You don't adjust that number. And there's a calculation here. The side of the screen that says minimum wage calculation shows you a very basic what the numbers would come out to if you had a server who was making $7.25 an hour and worked 50 hours a week. They would come out to $398.80, and you can see they had 40 hours at $7.25, and then they had 10 hours at $10.88, which is time and a half, and that's how we get to that number. On the other side of the slide is how this works with the tip credit. Again, we're going to take our straight time wages, $283, which is our tipped wage, times 40 hours. Then we have our tip credit, so $4.42 times 40 hours, and our total straight time earnings are $290.30. So pretty darn close to our straight time wages if we had just a regular minimum wage employee. Where it gets complicated is how we deal with this tip credit when calculating those extra 10 hours. We're used to just saying time and a half, right? Our bussers would just get time and a half. Our dishwashers would get time and a half. But we have a couple of extra hoops we have to jump through when figuring out what time and a half means for a tipped employee. So what we're actually going to do is we're going to go back to time and a half at $7.25, which is the $10.87. And we're going to subtract our tip credit because our tip credit always remains the same. And we come up with $6.45. So our half time for our tipped employees is the $6.45. And we're going to figure out that for those extra 10 hours they worked, they're going to get $6.45 times 10 hours, $64.50. They're still going to get their tip credit for those 10 hours and get $44.20. And at the end of the day, their total overtime hours are going to be the combination of the tip credit on those 10 extra hours and the OT cash wages on the 10 extra hours. And magically, when we get to the end of the day, they're going to earn $3.99, which is almost exactly what the $7.25 calculation is. We're off by 20 cents because, hey, sometimes that's just how math works. But at the end of the day, again, I doubt most of you are doing this by hand. It's just important to know that one of the fundamental rules for how the tip credit works is when you come up with time and a half, you don't do time and a half of your tip credit, you do time and a half based on the cash wages. So that's kind of our starting point. We're allowed to pay a lower cash wage. We have some special rules that allow us as employers to say, well, but you've got this money directly from customers, and I'm going to take some credit for that in making sure that you've earned minimum wage. Now, all of you have probably seen in the news really over the last couple of years that there's been a lot of angst and changing priorities when it comes to some very specific practices that are unique to your industry. And one of those is tip pooling. So the concept where rather than having all of our servers or housekeepers take their tips and put them in their pocket and take them home at the end of the day, we're going to collect them and we're going to redistribute them in some way that we think is more fair because it either evens out, the fact that some shifts are busier than others, or it evens out the fact that some people, get tips and some people don't. And there's a whole host of reasons why employers use tip pooling systems as opposed to just allowing employees to keep their tips. It really can be helpful in fostering teamwork. A lot of restaurants in particular have switched to a model where, as the consumer or the customer, someone takes your order, but someone else brings it, and another person comes by and fills your cup so that you have multiple touch points. It can help, it can help foster that feeling of collegiality where multiple people are taking responsibility for a table. It can be, that can be a factor as well when you have a huge table and you have, 2 or 3 servers dealing with the table. When it comes to housekeeping, we obviously want to ensure that our housekeepers are working as a team to get all the rooms done, so that if somebody's floor has 3 dirty rooms and somebody else's floor has 10 dirty rooms, we want to foster them working together to get it all done. Tip pooling is very big when there's a counter service model. So when you're going up and ordering, and there's not really someone coming and serving you at a table, there's a tip jar right there. I already talked about a multi-contact service model. Tip pooling can also really help encourage side work. I'm sure that you've all experienced, the difference in employee personalities. And sometimes we have employees who just want to serve, and they're the hardest people to get to help roll silverware or marry condiments because they're not going to take time away from earning, the almighty dollar. So by having a tip pooling system, it kind of helps to distribute all of that work so that people who are more inclined to help out with side work aren't sort of being punished or earning less because they're taking time to help the good of the establishment. It can help with issues with table assignments where people aren't feeling like, well, why has this person got the better section or the bigger tables? It certainly, again, in addition to fostering teamwork, increases a sense of responsibility. The biggest change in tip pooling in recent years has really been to try and include back of house employees. And there's really 2 main reasons for that. One, there's really been a little bit of a shift in the industry's mentality of making the dining experience really a whole food experience. There's been a lot of concepts with farm to table coming out of meeting the chef. And it really helps to promote that concept that your link as a customer to the establishment is not just the person serving your food. It's also, realistically a way to help increase back of house wages. For years, dishwashers and bussers and kitchen staff have kind of griped that, well, I only make, $8 an hour, and the servers, they end up taking $200 or $300 home a night. And, how's that fair? We're both vital to making sure the customer has a positive experience. And by tip pooling, you're kind of helping to redistribute that so that everybody's really experiencing and enjoying the benefit of getting the tip. So those are some reasons why it happens. And the question is, well, what are we allowed to do? And the answer to that question has changed over the years. And there's a timeline here that kind of gives you some of the major points. And I'm not going to go through every single discrete little point on the slide, but here's the general picture. The FLSA, or the Fair Labor Standards Act, went and Congress added the tipped wage provisions. So the ability to pay a lower cash wage and take a tip credit back in 1966. Pennsylvania followed shortly thereafter in 1968. Both of those laws specifically say that tip pooling is allowed among employees that customarily and regularly receive tips. So your servers who all earn tips as part of their job can tip pool. Your housekeepers can tip pool. If you're in the nail business, your nail technicians who customarily receive tips can tip pool. The law says, hey, that's fine. But the law didn't really say anything about, well, what if you pay the minimum wage? Are you allowed to tip pool then? So tip pooling was expressly allowed if you were taking the tip credit, but it was limited to tipped employees that customarily receive tips. The law didn't address the fact that some employers just choose to pay $7.25. They don't want to be bothered dealing with the whole tip credit system. And there was nothing in the law that addressed whether those employers were allowed to do tip pooling. So the practice really kind of grew organically. And the thought was, well, the law doesn't say we can't do it. And realistically, if we're not taking a tip credit, we believe that we can tip pool, and we believe that we can tip pool among just our tipped employees, but also we are going to tip pool among everybody. And if we're paying the minimum wage and everybody's earning the same, the servers, the kitchen staff, the bussers, and the hostess, what does it matter if we're including everyone in our tip pool? Because we're not making adjustments to wages. We're not paying one group of people less and another group of people more. So for years, that was a practice that really didn't get a lot of attention, was generally accepted. And then in 2010, the Ninth Circuit, which is the California side of the country, which Andrea and I will tell you as lawyers, we always look at what they do with a little bit of a suspicious eye, because they're usually not aligned with the rest of the country, and they tend to take very liberal positions. Here, they actually came up with a pretty sound decision, which was to say that if employers do not take a tip credit, everybody earns at least $7.25 or more an hour, then it is perfectly acceptable to include any employees that you want in the tip pool. You can include servers and cooks. You can include bartenders and kitchen staff, dishwashers, hosts. If you are always paying the minimum wage, anybody can be in your tip pool. You don't have to carve out different groups of people, which is different than when you take the tip credit, because when you take the tip credit, you have to exclude all of those other employees who earn $7.25 or more. So that was the holding in 2010. The industry is feeling great. We're feeling relieved because everything we've been doing for the last 50 years is legitimate. And then what happens? What happens is the president's administration decides they want to get involved. And I'm sure as employers, you know how difficult that can be when administrations say one thing and then another administration comes in and another administration comes in. And that's kind of our theme today, as you'll see as we go through some of these issues. So in 2011, the Department of Labor that was in place under President Obama basically issued regulations saying, we don't agree. And our opinion is that tip pools must be restricted to tipped employees, regardless of whether you take the tip credit or not. So in 2011, rule changes. You can have tip pools. They can only include your servers and bartenders, nobody else. And that's the final word on it. And there was a lot of heartache about that. In Oregon, the Oregon Restaurant and Lodging Association took a legal challenge all the way up again to the Ninth Circuit, basically saying this is not acceptable. You know, this is impacting our ability to do business. And frankly, and most importantly, it's not part of the law. So why can't we do this? And unfortunately, the Ninth Circuit in this case sort of said, well, our hands are tied. The Department of Labor has the right to do this, and we're going to leave the rule the way it is. And then in 2017, we have a new president, and we have a new set of presidential priorities and department priorities, and the rule goes away. The Department of Labor basically says, oh, you know what? We don't think we're going to do this anymore. We're not going to enforce. We're okay with going back to the old tip pooling rules. And then that actually ends up becoming the law. So in 2018, in the budget for the year, Congress said, we're going back to the tip pooling rules that say, if you take the credit, you can only include servers. If you don't take the credit, you can include everyone. And then in 2020, and I'm sure that you all sat through a ton of webinars on this, there was a big tip rule that came out from the Department of Labor at the end of 2020 that formally adopted the position saying that if you pay $7.25 or more an hour to your servers and you do not take the tip credit, your tip pools can include everyone. So that's where we're at today. And the basic rules are on our next slide. And I've said them, so I won't belabor it. If you take a tip credit, you are allowed to have a tip pool, but it's limited to your servers and bartenders and other employees that customarily and regularly receive tips. So those two things go hand in hand. Tip credit and limited tip pool go together. If you do not take a tip credit, you may require a pool, and it can include anyone and everyone. So again, in that case, they come apart. And the pools, frankly, they're mandatory, right? I mean, you're not going to have a voluntary tip pool where some people have to contribute and some people don't. If you have a tip pool, the rule is everybody puts the money in the pot and then the money is distributed. And there are different ways that it's distributed. Some employers will distribute the entire pool evenly. Some employers will use some kind of calculation that they've developed that reflects the amount of work that they think went into serving the customer or the contributions by different positions. You can have different ways of doing that. But if you're going to include anybody from the back of the house, you cannot take the tip credit. And then we have some general rules that apply to every employer who tip pools, regardless if it's a limited tip pool or a broad tip pool. You must fully redistribute the tips no less often than when you pay your wages. So you distribute on payday. I actually talked to a client this week who was distributing once a month, and they were paying bi-weekly. So they have to change their schedule, and nobody complained about it. It just sort of came up in a casual conversation between me and that person. It's like, well, distribute twice a month instead of once a month. Employers may not keep tips for any purpose. So there's no, well, the house keeps 10%. There's no holding back 10 or 20% because it's not fair that managers and supervisors get nothing. The establishment and managers and supervisors of the establishment are not allowed to keep anything and are not allowed to be included in the pool. And of course, the concept there is that managers and supervisors are being paid more, so they don't need to be dipping into the tip jar. And then our last bullet point, which you will see has a TBD, is employers are not permitted to retain tips. And if they do, they can be fined. There can be penalties imposed if you go through a Department of Labor process. And the reason that there is a TBD there is because there were penalties set in the 2020 tip rule. And then when the Biden administration came in, they made a decision that the penalties really were not clear and the penalties did not comply with what Congress required. And so those penalties were pulled back, and they are expected to be reissued later this year. So there will be penalties. We just don't know what they are just yet. There's a question.
Real quick, yeah, there's a question, but I think before the question, just something to note for you all, and I'm sure you all know this already, but in order to make sure that you're taking you have people who are able to be a part of the tip pool, you need to make sure that you have written documentation from everyone who is a participant, because then if you wind up in potential litigation, you need to be able to produce those documents that everyone has agreed to, and been provided with sufficient information about the tip pool. As I'm sure you all know, and the reason why you're all participating, there's been a ton of litigation in this area over the last few years, and just important to make sure that you have all your ducks in a row in case you wind up in that unfortunate position. So.
Fair enough. I mean, certainly your employee handbook is an appropriate place to disclose that, which everybody should be signing off on. There are a couple questions I want to hit quick before we move on to the next topic. So first question is, and I think we're on the slide. Okay. Somebody asked, it says servers and bartenders. Does that also include bussers? That's going to really be dependent on your business and the question of whether your bussers customarily and regularly receive tips. I've certainly worked at places where bussers did not receive tips. And so those people, in that scenario, they would not be considered customarily and regularly receiving tips, and they would not be permitted to participate in a limited tip pool. On the other hand, if you're in an establishment where bussers do customarily and regularly receive tips, then in that case, they could be included in the limited pool. Although my sense, and I will admit I'm not necessarily an expert on every practice in the industry, my sense is that when bussers are getting tips, it's usually a split where the server is giving some to the busser. And I think in that case, where the busser themselves is not the actual recipient of the tip, they really should not be included in a limited pool. Next question. What if one lead server receives over minimum wage, but employer uses tip credit with other servers Does that permit sharing with back of house? Employer uses tip credit with other servers. No. If you are ever using the tip credit for anybody, then the use of the tip credit automatically means that the employees who are taking the reduced wage and having the tip credit assessed on their payroll get to keep all of their tips. Now, is the question of whether the lead server could have to pull their tips with the back of the house. That's not really answered by the regulations, but I think from a practical perspective, I would discourage that because frankly, not from a legal perspective, that's really going to be a big morale problem. I mean, that's going to be like, okay, so we're punishing the top performer by making them share out their tips, but we're not making anyone else do that. So in the case of whether you can do it, if you have anybody who's getting the tip credit, your pool is going to just be limited to those people. So it's going to be that those servers are pooling amongst themselves just to make sure that one person doesn't serve a 20-person birthday party and get, a $700 tip while everyone else got, $5 and $10 tips throughout the night. It's kind of more evenly distribute that. Although, of course, on the flip side, maybe the person who served the 25-person birthday party should get the $700 tip because they might have worked harder than everybody else who did tape 2 tops for the night. What about hourly line managers? I think anyone you call a manager is out. They're receiving a higher hourly wage if they have any kind of supervisory duties. And the reason I focus on that is because in the law, there's kind of a little bit of a difference between a manager and a supervisor. A manager is viewed as someone higher level, and a supervisor often includes exactly the kind of line manager you're talking about. It's a lower level person who doesn't really have decision-making authority, but they have some type of authority. They have some increased responsibility, and they have an increased wage. So I think even a line manager is considered a manager of the establishment. And that's not to say that in your own special, unique circumstances, you might not have some argument. But in general, if they have supervisor or manager in their name and they're earning a higher wage than other people, they're out.
Yeah, but I would just say oftentimes organizations use the word manager in a colloquial sense. And so it's really a functional assessment. So that's an important thing to note. Also, if you have folks who are doing, some shifts they're servers and some shifts they're quote managers, then you're dealing with dual jobs, which we're going to talk about in a little bit.
Okay. Can you have different groups of tip pooling? Example, bartenders who pool and from their tips they share to pool a pool of support staff? Yes. You can organize your tip pools in different ways. Again, in that particular example, where it would be support staff, your bartenders would have to be making $7.25, but there, you can look at your business and decide who's helping who. I mean, a tip pool that is just servers who make $7.25 an hour and bussers, you may limit the tip pool to just that group of people because the thought is, well, the servers can't really do their job if the bussers aren't doing theirs. They're working as a team. Same thing in the bar. If you have bar staff and you have some kind of support staff that are limited to the bar, maybe you have somebody who's not serving drinks, but is responsible for collecting all the glasses, running them through the at bar dishwasher. You might have a theory there that should be a pool because the bartender is really able to serve the drinks and talk and entertain because there's support staff in that area. And that's okay. All right, there's a couple of other questions. I'm going to put them on hold for now until we get to the end. One, because I want to get through this and respect your time. And two, because some of them are getting extremely specific. And so they're a little bit more one-on-one questions.
Yeah,
That's the general. Go ahead, Andrea.
Just real quick, the only thing I would say is if you're going to have not a general practice for everyone, it's really important for people to sign off specifically that their tip pool includes X category of workers and Y category of workers. Again, because if you have any type of challenge to the tip pool, you need to have that and make sure that people have signed off on that. So something to think about if you try to create different tip pools.
All right. The tip pooling issue, by and large, except for a couple of special circumstances or specific questions, is resolved. The question now is, what about dual jobs, the dual job standards? And this is a little bit of an open issue because there is a regulation pending that has not been finalized, which means there's an opportunity for you to actually influence the process. So what do I mean by dual jobs? In the original regulations issued by the Department of Labor concerning tipped employees, the department recognized this concept that sometimes in our businesses, we have employees that are doing more than one thing. And I can speak from that personally. You know, when I was a server, sometimes I was a busser and sometimes I was a hostess. It just depended on what the week required. In 1967, when these regulations were put into place, the concept of dual jobs was pretty black and white. The example that was given was a maintenance person at a hotel who also sometimes served as a waiter. And most of us can probably pretty easily see where the DOL was going to go with that. You could take a tip credit when the person was serving as a waiter. You could not take a tip credit when the person was doing work as a maintenance man. And that pretty much makes sense. The other example that was given in 1967 was the concept of, and I'm using waitress and waiter here because that was the language at the time. I know we've moved off of that a little bit. The regulations address the concept of, well, what about a waitress who does all these other things, cleans and set tables? That should be toasting bread, not toasting bread. Toasting bread, making coffee, washing dishes or glasses, or a counterman who is, taking short orders, but serving at a counter, serving, filling drinks, those sorts of things. In the original regulations, those were not considered dual jobs. All of those other little side tasks were considered to be part and parcel of the tipped job. And so you could take a tip credit for all of those things. Inevitably, however, the Department of Labor just can't help themselves, right? They just can't leave well enough alone. And as time goes by and regulations get more complicated, they start to stick their toe into that second set of examples, the waitress and the counterman, and put more parameters and more guardrails on it to really create more confusion for us, more confusion for you in the industry, and more lawsuits. So 1988, you can see the big red stop sign. The Department of Labor, this wasn't actually something that they issued to the industry or the public. This was something that they issued to their own investigators. They updated their field operations handbook, which is sort of the Bible for DOL investigators, to include what kind of became known in the years since as the 80-20 rule. And what the 80-20 rule looked at was the concept that 80% of somebody's time in a tipped occupation had to be spent on tipped work. And they were allowed to have a 20% bumper of time doing other things like rolling silverware or cleaning the bathroom or cleaning tables or mopping the floors. And, look, we've all been in businesses, sometimes those are the duties that need to be done in order for the business to function. And, sometimes our host is leaving at 8 and the restaurant is open until 9. Well, guess what? The host is no longer available to clean the bathroom, so it looks like a server's doing it. There's certainly a lot of opening tasks that have to happen. So that became the standard by which dual jobs were measured. And if the Department of Labor determined that more than 20% of a server's time was spent doing other stuff, then we had a problem. And the tip credit was not supposed to be used in those situations. And I know, in the litigation world, this became a big issue because how do you really measure whether somebody has spent 20% of their day doing serving tasks or non-serving tasks? So we kind of worked through the process. I think people in the industry did their best to kind of try and comply with that rule. And it really was the rule and sort of the law of the land for a long time until 2009, when the DOL kind of decided they didn't really like it. So they suspended it. Then in 2018, they decided, well, we're going to make some other changes. And, we had a lot of lack of clarity over the years about what the rule was. I think generally people kind of stuck with it. But in 2018, we had a major change, and this was a major change that happened under the Trump administration. And regardless of what your political affiliation is, there's no doubt that some of the things the Department of Labor did under the Trump administration were viewed as more business friendly. And one of them was this rule. The Trump Department of Labor basically said, we don't like the 80-20 rule, we're throwing it out. And instead, we're going to allow a tip credit if non-tipped work is performed contemporaneously with or immediately before or after tipped work. So that took into account the fact that once you served the table and they left, you had to clean it. That took into account the fact that during a shift, somebody might have to roll silverware. That took into account the fact that just before the first table was served, somebody was making coffee. It was definitely a little more loose of a standard, and it gave employers a little more wiggle room to not have to be worried about tracking every minute of the day. Where did we go from there? In 2020, that standard was included in the 2020 tip rule that received a lot of attention at the end of last year. And then change in president, right? All these things that happened under President Trump went into effect, and President Biden came in and said, well, I don't really don't agree with those things. In the beginning of 2021, a couple of things happened that really changed the direction on the dual jobs rule. One, several states' attorney generals basically said, we don't like the new standard. We think the 80-20 rule was the way to go, and we want you to put it back. And two, the Biden administration issued a freeze on all regulations that were pending and had yet to be finalized from the Trump administration, and basically told all of the agencies to say, told all of the agencies, you need to look at all these regulations and you need to evaluate, whether they are consistent with what the priorities are of the administration and whether they're consistent with the law. And you may need to withdraw them or adjust them or change them. And that's exactly what the Department of Labor did. The Department of Labor looked at the 2020 tip rule and said, we're going to let like 80% of this go into effect, but we have some concerns about this elimination of the 80-20 rule. And then in June, they came back and said, we've looked at it, we have a better idea. And so right now, what is pending is the 2021 new rule for dual jobs. And it is a proposed rule at this point in time because it's still in the comment period. And can you just go back one sec? 8/23 is our comment period deadline. So as a result of this webinar or any other materials that you've read about this, if you feel strongly that this needs to be changed, or you feel strongly that the Department of Labor has gotten it right, that's your deadline to go online and submit comments either in favor of the rule or proposing changes. And I encourage all of you to do it. It's very easy now because you just go on and do it. Basically, you type it in and hit submit on the internet. Okay, so the new rule is slightly different than the 80-20 rule. And it basically takes the whole host of things that a tipped employee might have to do during their workday and puts them into two buckets. Bucket one is work that is, quote, part of the tipped occupation. And bucket two is work that is not part of the tipped occupation. And we're going to talk through what these two buckets mean and how they work. So bucket number one, work that is part of the tipped occupation. Work can be part of the tipped occupation if it meets one of two criteria. One, it produces tips. That seems pretty self-explanatory, but in fact, it may not be. So a server serving tables, that's an easy way to look at it. Or two, it directly supports tip producing work. So there are a whole host of tasks that as business establishments, we understand serving tables isn't just taking the order, putting the order in the computer and or writing it on a ticket and giving it to the cooks, picking up the order when it's done and handing it to the table. It's way more than that, right? It's filling drinks. It's making sure that there's clean menus. It's making sure that there's rolled silverware and set tables. It's making coffee in the morning. It's doing all kinds of different things. It's going back and having questions answered. It's dealing with disputes over the bill or disputes over the fact that somebody didn't like something. That is the second category of tasks, which is called work that directly supports the tip producing work. Things that a server needs to do in order to be able to serve a table and make work. And the department has actually given us some examples here, although again, their examples might be a little too surface level black and white than we would care for. So examples of work that produces tips: a server waiting tables, a bartender serving drinks and talking to customers, a nail tech performing manicures and pedicures. Those are kind of the obvious tasks that would produce a tip. Work that directly supports tip producing work is work if it assists a tip employee to perform the work for which they receive tips, and that can include a server preparing items for tables, a bartender cutting fruit for drinks, a nail technician cleaning pedicure baths between customers. So that's bucket one. What does that mean with respect to the tip credit? Anything that falls in bucket one is subject to the tip credit. So anytime that our employee spends serving drinks at the bar and kibitzing with customers, or dealing with serving a table and all the little tasks that go with it, fall in bucket one and can receive the tip credit. Except, right, because there's always an except when it comes to the Department of Labor, we have to look at the second category of work that directly supports tip producing work. So directly supporting work cannot take more than a substantial amount of time. And this is where we get back to the good old 80-20 rule. When is directly supporting work considered to be substantial? Well, one measure is the 80-20 rule, and we would take the 80-20 rule on a work week. So if during a work week, 80% of somebody's time is spent, directly supporting work can't exceed 20%. So we can't have somebody spending 30% of their week rolling silverware and making toast and making coffee, because then they're doing a substantial amount of supporting work, and that's cutting into the time that they should be spending actually doing work that produces tips. Our other measure is during a work day. So in a single shift, if somebody's, and I'm going to use kind of the colloquial industry term here, if somebody's side work is taking more than 30 minutes of a single shift, suddenly it's become substantial, and now we have a tip credit problem. And the tip credit problem is not that the tip credit totally goes away or that we're disqualified from using it. It means that the tip credit cannot be taken for time that exceeds substantial time. And this is where it's like, this is where the Department of Labor is really asking us to split hairs and get down to the nitty gritty. So for example, if I have an employee who's working 8 hours and they have 30 minutes of side work at the start of their shift and 30 minutes of side work at the end of their shift, now they have 60 minutes. And the rule is I'm limited to 30. So I'm allowed to take the tip credit for the first 30 minutes that they did side work, but for the second 30 minutes they did side work, I have to pay minimum wage because I'm no longer allowed to take the tip credit. So you can see this is making you get really, 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 really specific about what your employees are doing. And we're going to come back to this and talk through some practical recommendations for how to deal with that. But I want to talk to you really quickly about bucket number 2 first. So bucket number 2 is work that is not, not part of the tipped occupation. Again, some of these seem a little obvious, but basically bucket number 2 is everything else. Work that does not generate tips and work that does not support tip producing work. So a server cleaning the restrooms, a bartender cleaning the dining room, a nail tech ordering supplies. If your servers or bartenders are doing any of these things, that is not tipped work. And an employer can't take the tip credit for time spent on these tasks. And that's our rule. If it falls in bucket 1, we can take the tip credit as long as we don't go over the time thresholds. But if it falls in bucket 2, no tip credit, must pay minimum wage. Where's this going to get us? Because that's really the question you all want answered. Well, the first real issue is the concern over a lack of clarity in whether tips are part of bucket 1 or whether they fall in bucket 2. There's a lot of tasks that really are on the edge. And I can make an argument that they go in bucket 1, and you can make an argument that they go in bucket 2. So my example is, I know in my past when I was a server, if somebody got a side salad, I had to make it. And if somebody got soup, I had to make it. That was not the kitchen staff's responsibility. There was a nice little station in the kitchen where the servers would do that and we would take it out. One person could argue that that's a directly supporting task because it is necessary to serve the customer. Someone else, the Department of Labor, for example, could argue, well, no, that's actually not a directly supporting task because that involves food preparation, and that is something that falls solely within the realm of the kitchen staff. So the regulation kind of leaves up in the air what tasks go into what bucket, and that's of course where we get into the problem of, well, that's all going to develop through enforcement and the court system and lawyers having to make arguments and associations like the Pennsylvania Restaurant and Lodging Association having to advocate positions. And that's not really a place as employers where we want to be. We want to have clarity. We want to have the list of 6,000,007 items that tells us exactly what goes into what bucket. As I sit here and think of other tasks, inventory. So, bartenders in particular are going to do their own inventory and say, okay, we need more of, Grey Goose. We need more of Tito's. We're not going to send a separate manager. Most of the time, we're not sending a management level employee to take stock and come back with an order. I think, quite honestly, under this regulation, that's going to be not part of the tipped occupation because doing inventory isn't producing tips. And it's really not being done in the moment to serve a customer and get tips. There's no question it's vital to the job. There's no question it needs to be done in order for us to ultimately serve a customer. But if your bartenders are doing that role, just like the nail tech example, inventorying how many bottles of gel nail polish we have and how many things we have of acrylic, that's not a tipped duty, and it's not going to be considered part of a tipped occupation. That really has to be performed by some type of administrative or management support staff. So issue number one is we don't have a comprehensive list. What are we going to do about issue number one? Well, as Andrea said before, a lot of this comes down as taking a critical look at what our people are doing, evaluating it and documenting it and moving things as needed. And you can go ahead to the next slide. So I know you get tired of hearing labor and employment attorneys tell you this, but it cannot be overstated. Update your job descriptions. Look at everything that your tipped employees are doing and critically evaluate each task. What is your argument for why this either produces a tip or directly supports tip producing work, and why it doesn't fall into the realm of the busser or the kitchen person or another position at your establishment? You may have to reassign some tasks. I mean, realistically, if you have servers and bartenders cleaning the bathroom, that needs to go to someone else. Either a custodian or a host or a busser needs to take over that role because the DOL has already said that is not tip producing or supporting of tipped work. That can include, mopping the floor to the entranceway, vacuuming the dining room, all those different things that frankly, we expect our team members to do as good team members who are trying to help the business keep going may need to be shuffled around to be somebody else's problem. And then you're going to have to really think about and substantiate the tasks that are on the line and explain how they produce tip producing work. You have resources for that. This organization in particular can help in providing resources with that. There's also, and I'm not going to spend 20 minutes on it, but there is a federal resource that the Department of Labor sometimes refers to, which is a list of occupations. Although unfortunately, that doesn't necessarily get down to every specific task, but you're really going to have to think through your argument why. You should be talking to the organization, you should be talking to the Restaurant and Lodging Association, you should be talking with your counsel, and you should be using common sense in explaining how these things go together. The other major concern, and I'm just checking my time here, the other major concern is if we're going to have, well, there's no question of if, we're going to have tipped people doing side work and other things that we consider to be directly supporting. And as long as they're doing that, and there's no way around it, we have to think about how we're going to track it. Because once they hit 20% of the week or 30 minutes in a day, we have to change the way they are paid. Any time that exceeds the 20% in a week threshold or the 30 minutes in a day threshold, they have to be kicked into minimum wage. So I kind of gave you the example earlier. I won't spend a lot of time repeating them. If we have an employee that spends 35% of the week performing supporting tasks, so they go in bucket one, but they're supporting, you can take the tip credit for the first 20% of their time, but the remaining 15% must be paid at minimum wage. Similar to a work day, if they spend 50 minutes of an 8-hour shift doing supporting tasks that go in bucket one, you can take the tip credit for 30 minutes, but you can't for the remaining 20. They have to be paid at minimum wage. This is a nightmare. I mean, this is an absolute nightmare. How are we going to deal with this?
So
Well,
real
go ahead,
quick,
Andrea.
yeah, real quick, just because I think, one of the other things you all are thinking about, like who to assign these tasks to. And so you just need to be careful not to overcorrect and give managers responsibility for doing non-management related tasks. There has been, on the flip side, a significant amount of what I would call misclassification litigation, people who were supervisors or managers. And the argument is, well, that was their title, but really they dealt with all of these administrative tasks. So make sure that you're not, solving one problem and creating another. The other thing is many of these things in this dual jobs proposed rule, like obviously the 30-minute threshold is not in place yet. There's still comment periods, but many of these undergirding issues are an issue raised in litigation on a regular basis, and the tracking issue as to what people should or shouldn't be doing and aren't doing is really important, even if this dual jobs rule doesn't go into place, because we litigate these things every day, and trying to then in a context of litigation prove that someone spent less than 30 minutes on side work or spent time doing X and Y is very challenging. So trying to think through how you're going to defend that case to the extent you're stuck in it is important, even if this dual jobs regulation doesn't go into effect.
That's a good point, especially the point about the managers, because then you're kind of bringing in the threat to your exemptions if you have people who are salaried and not earning overtime. So what are some ways we can deal with this? Again, we're not talking about the scenario where on Monday someone's a server and on Tuesday they're a host. That's very clear. When they're a host, they're getting $7.25 or more an hour. We're talking about this division between serving the table, doing something that helps serve the table, and cleaning the bathrooms. So when we're talking about bucket one of the nice things is we're having this webinar early enough for you to take a time period to evaluate what's happening in your establishment. This rule is not final. We're still in the comment period. Normally after the comment period, there's some redoing of things. And we may have till the end of the year, if not longer, before this actually goes into play. So you have a measurement period where you can look at what your people are doing and measure it and decide how close you are on the 30-minute or the 20% rule. You can have your staff be doing timesheets, not for the purpose of getting paid, but to track what they're doing throughout the day. You can have a clocking in and out system. I mean, if you have, a very easy way to deal with opening and closing side work is to clock separately for those two things so that time is being recorded separately. Now that doesn't help the fact that, mid-shift if someone has a lull, they might, fold napkins or roll tableware, but there's very clearly a set of side work tasks. I mean, in my life, the last 20 minutes was marrying ketchups, right? So that could easily be a clock in and out scenario. Reassign side work tasks to non-tip staffs, again, being mindful of not overloading your salaried exempt managers with non-managerial work. You've got bussers, you've got hosts, maybe you don't. I mean, you may be in a small organization or a small establishment where it's, one or two servers and a counter position, and you're really going to have to think through how some of these tasks are going to be done. I mean, there's burger joints out there. There's take and go establishments where there aren't other people to assign this work to. And in that case, you may have to look at, a clocking in and out system. There's always the concept as well of using this time period to evaluate the economics of your business and to figure out whether you could handle the hit of moving everyone to 725. I mean, the easiest solution in terms of practicality is often the hardest in terms of the dollars. And that's another analysis, which is to say, look, I'm a small counter service establishment. I really cannot be going back and forth and having people clocking in, clocking out, tracking all this stuff. I got 3 people, I'm making them all 725. And that's a valid position as well. What I would encourage you to do is use this next 3 to 6 months to run your numbers, look at what your people are doing, and try and find a way to measure what they're doing so that you can make a reasonable choice. Because oftentimes what happens is we're very removed from what our employees are doing, and we think we know what they're doing. And then when we see the numbers, it's very different. I mean, you might have one server report, well, I only spend, I track my time and they spend 10% of their time doing side work because they want to serve. You may have someone else who's spending, 45% of their time doing support tasks. And you're going to have to make a decision about whether it makes sense to change some of these roles, change your pay rates, and have a different clocking in and out system. But you actually have the time right now to figure that out without having a consequence. All right, one bonus topic for today is an update on the salaried employee status in Pennsylvania. Andrea did a webinar for all of you earlier this year talking about the fact that in Pennsylvania, we had adopted, the Pennsylvania Department of Labor and Industry had originally put in some salary thresholds that exceeded what the federal government was requiring. And without going and taking a ton of time on this, and I'll summarize it very quickly, you may remember that when President Obama was going out of office, the DOL tried to ram through a very high increase in the salary thresholds, mostly because the president had told them to do that at the start of his time in office, and they did not do it. And so at the last minute, they kind of had to try and figure it out. There was all kinds of legal challenges. It basically went from $23,000 to almost $50,000. People went crazy. Employers went crazy. It was tied up in the court system. And when the Trump administration came in, they said, we're not following this. We're going to take a look at it and reissue it. And the federal government came out with what you see in the gray box, $684 a week. So that is currently what's required under federal law, and it's currently what's required under Pennsylvania law for our salaried employees. And I'm talking about executive, administrative, and professional employees, the white collar positions. In 2020, Pennsylvania decided to go a step further and have an increase that happened in October 3rd of 2021. That actually should be October 3rd of 2022. That basically each year it was going to get higher and higher to pretty much almost get to where the Obama administration was aiming for. And so we had been telling you earlier this year, prepare. On October 3rd, it's going up to $46,000 a year. That's a pretty big jump. Make sure you're prepared. Well, as all things happen in politics, there's a lot of horse trading. This year, as part of the budget process, Governor Wolf actually agreed to cut the remaining increases in 21, 22, and 23 in exchange for getting some things funded as part of his budget process. So on July 9th, the House actually passed and it was approved into law. It's basically one of the 3 laws that gets amended every time they pass a budget. They delete all the old stuff and put in all the new stuff. There was an actual repeal of these salary increases. So as of October 3rd, you do not have to plan to get to $46,000 a year for your managers and executives. The thing that was somewhat interesting, and maybe it's only interesting to me and Andrea because we're legal nerds, is that they didn't just take out the numbers. They actually took out all of the regulations in Pennsylvania governing the executive, administrative, and professional exemptions. So the parts of the regulations that tell you, well, what does it mean to be an executive employee? How many people do you have to supervise? What kind of authority do you have to have for the company? They wiped it all out. I don't know if that was on purpose or if that was just sloppiness, which sometimes happens. So as of right now, we are absent some guidance in Pennsylvania under our state law. However, I'm sure you all know those concepts are fully fleshed out in federal law. So we're not completely resourceless. We still have to follow all the rules the Department of Labor tells us for what it means to be a salaried person. And just as a quick refresher, that means 2 things. 1, it means you make the amount of money that you have to make. $35,568 a year, and 2, that your duties are consistent with what the Department of Labor says they need to be a salaried person, that you're not a laborer, that you're making decisions, you're exercising judgment, you have authority over employees, over hiring and firing, over decision making for the company. So if this was on your slate to increase in October, you can take a breather. If you've already done it, I'm sorry. It was kind of an 11th hour change by our Congress and our governor. And I'm sure your employees will be happy, but that's just a quick update on that. I'm going to check the chat quick. I don't want to keep people longer than they plan to be here. I know I'm a little over. I think this was answered, but yes, this was recorded. There's also a PDF of the slides that will go out.
There were just 2 questions at the beginning that you said you were
Okay.
going to come back to. Amy and Andrew had 2. There were the 2 questions.
So Amy had a question. If you have 2 different restaurants under one LLC, one is traditional sit down with tip pooling, including back of house, and the other is a pizzeria that does not take the tip credit and pulls tips between cashiers and back of house. I think that for this rule, Andrea, tell me if you disagree, these would be treated as separate establishments.
They can be, but it's possible that they would be, if the servers work at both locations, and if they're functionally operated as one entity, even if there are, then I think that you would have to go across entities. You could treat them differently, but it's whether or not there's one LLC or 2 LLCs doesn't answer the question completely. There's also some joint employment shifting landscape as well here. So there's a lot to unpack there.
And then the other question had to do with
So Amy, we're happy to talk to you. Amy, we're happy to talk to you offline if you'd like, but it's a very specific question to make sure you address. Sorry.
The other question from Andrew: in a private event environment, the venue collects an 18 to 20% service charge on the event invoice. Okay, so this is not a restaurant. This would be, I assume, catering or an event venue that has a catering component, and it deals with the service fee. I mean, the question, I don't have quite enough facts to answer the question because I don't know what you're doing with the money afterwards. If you're taking that 20% and it's being distributed in lieu of the guest or the host of the event having to pay a cash tip, you're going to have implications under the tip credit rules and the tip pooling rules. If it's just a 20% service charge that's going to the company's bottom line and the guest is still potentially leaving a cash tip for the workers, you're going to be in a different scenario. If not taking the tip credit. Oh, well, go ahead, Andrea. I'll look at the next question.
Oh, yeah, no, and then there's the last question. Yes.
Okay. So if not taking a tip credit, are there any restrictions regarding tip pool distribution for partial shifts? One staff works 10 hours, another staff leaves early and works 8. No, if you are not taking the tip credit, you pretty much have authority to run your tip pool however you want. And, some people are going to take that as a straight, everybody's getting an even cut of the pool. If I have 10 people, everybody gets 10% of the pool. Other people are going to look at something more like, okay, if I have 3 full-time servers and 2 part-time servers, perhaps I'm going to give the full-time servers a greater cut of the pool than the part-time servers. And I didn't mean to limit that to servers. If you're not taking the tip credit, it can be anyone. So if if all your cooks are part-time, or better example, bussers. I feel like bussers oftentimes can be part-time. I mean, you can make decisions based on what the contribution is to the establishment to say somebody's going to get more or less of the pool. In this case, if somebody had one day where they left early and that's not normal, you can choose to treat them the same. It could be that the person working 10 hours is going to have a short shift sometime in the future. That's up to your discretion.
This just gets back to the disclosure issue. You just want to make sure that you're sharing a sufficient amount of information to comply with your disclosure obligations with regard to tip pools. So that again, you don't have people challenging that in litigation and saying that and then trying to throw out the tip pool because of the failure to get, have that disclosure.
Right. I mean, the other reason it's important to show that you've disclosed it, and this is the situation I had earlier this week, is that there was a belief that someone was not contributing, was basically stealing their tips. And, if that's not been advertised and, made clear, that's going to be, a difficult time enforcing that when somebody is choosing not to contribute or is sneakily not contributing. What if you have people who are managers and often servers? So one shift they are a manager and other shifts they are just a server. I think in that case, you're going to be under the dual jobs rule. And when they are in a server role, they're going to have the rules that apply to servers. They can be paid the tip, assuming that what they're doing during that server shift is just server work and they are not doing both. When they're a server, they're going to be paid as a server. When they're a manager, they're going to be paid as a manager. Where it's going to be more complicated is if during their server shifts, they're still doing management duties, either because that's just part of the deal or because all the other employees are used to seeing them in a management capacity. So every time they have a problem, they take it to that person.
The other issue is if the person is a manager and they're paid a salary as a manager and they qualify as exempt under the white collar exemptions, then that proceed with extreme caution. That's a very complicated question that requires a significant conversation. And so I would say before you do that with exempt people, you need to seek legal advice and get
I totally agree.
And get counsel and provide specific information in detail because be careful.
Yeah, and I will disclaimer that I took that question to mean they were an hourly manager. Andrea is 100% right. If you have a salaried manager, they shouldn't be filling in as a server. They just shouldn't. It's just too much of a mess. And that's not to say that, look, I recognize the fact that managers and owners even often have to roll up their sleeves and pitch in. And that's not to say there's not going to be some rare occasion where, someone called off for the day and the manager has to fill in. But if you are actively scheduling them in both roles, they better be an hourly paid manager. That's the last question I see. We both really appreciate your time and hope that you got something out of this. Again, Andrea and I are both with Posted Schell, and advising employers is what we do for a living. And so we were happy to share our time with you today.
Thank you so much. This was so informative. And I know that this is probably something we'll bring you back for later in the year because things are ever changing and there'll be more questions that come up. As we said, we did record this. We will send it out. We will share the PDF. Their information, their direct contact information is listed here for you to reach out if you have additional questions, or you can direct them to us and we'll try and help you out our best that we can. But thanks for joining us this morning. Thanks, ladies, for joining us and presenting this very important information to our members. And as you can see, everybody's saying thank you. Thank you, thank you, thank you. Like through here.
Well, thank you for the opportunity. And I'm sure when this rule goes into effect, something will be different. So
I'm sure.
Yeah, this is to be continued.
Yeah, exactly. It's never a growing situation. So well, everybody have a great rest of the week. You ladies have a wonderful week too. And thank you for your time.
Thank you.
Bye.
Bye.